welcome. I'm so happy to see some familiar faces here from last week, so thank you for returning. I'm excited to see you, and thank you to everyone who is new here this evening for our second week of navigating your options during the aging journey, or the journey of aging. My name is Cheryl Jeffers, and I am the Executive Director of CARE, Community Aging Resource Experts. And what we do is we provide free resources as a team to help you navigate those next steps and get your questions answered. CARE was started 5 years ago now, and it was started after my mom passed away from ALS. It happened very quickly. She was diagnosed very young, late 60s. Mom and Dad were in the family home. We had to very quickly downsize, move them into a one floor plan, do home modifications, home care, hospice, finances, power of attorneys, advance directives, work out some trust, will issues. And after that experience with my mom, after being in healthcare for 30 years and having a network of people, one thing I did not have was a network of people outside of healthcare, meaning the attorneys, the financial advisors, how to downsize, how to get rid of stuff. So I decided after my mom passed away, she worked for the Catholic Church for 35 years. She worked for St. Maximilian Kolbe in Westchester and St. John's in Westchester. She was a servant leader, and I decided after my mom passed that I wanted to continue that servant leadership, build a village of people that could do just that, help all of you with the questions that you need answered in order to navigate successfully. And that is our goal, is to help you navigate successfully. So tonight we are talking about estate planning and retirement. That is an exciting topic. And to start us off is Moinca Dwyer, and Moinca is a certified financial planner. She is with Harvest Financial, and she is going to start us off this evening.
Thanks, Cheryl. So, as Cheryl mentioned, I work with Harvest Financial, and today what we're going to talk about is estate planning. What is it? What you should consider, what kind of documents you might need, what you need to worry about in terms of your assets and trusts, and we can also talk about your digital life a little bit. We've got a couple of free offerings at the end. But let me introduce myself first. As Cheryl said, I'm a certified financial planner. I work with Harvest Financial, and our primary wheelhouse of what we do is asset management, and we couple that with full financial planning. And one piece of that full financial planning is estate planning, and that's mainly what we're going to talk about tonight. So I just want to tell you a little bit about what a financial planner does. We educate our clients on their assets. We help them manage their money to meet whatever their long-term goals are, and that can vary from person to person. A certified financial planner has additional training in all of the different areas of financial planning. We're required to pass a test and continuing education, but we also are required to act as a fiduciary for our clients, and that's probably the most important thing, is that the CFP board holds our feet to the fire for that. Some firms, like Harvest Financial Advisors, do asset management in addition to financial planning. In fact, most firms do. The question is, do they do financial planning in addition to asset management? So these are different areas of financial planning, but I think what we're really here to focus on is the estate planning. And so without further ado, I'm going to introduce Chris Lavin, who is an estate planning attorney, and he'll tell you a little bit more.
Thank you, Moinca. And as Moinca mentioned, we are an elder law firm certified in what we do. And we've been doing this for the last 28 years or so, and we're kind of a one-trick pony, so we don't get off the beaten path. And that's important because we're not doing divorces one day, criminal work the next day, workers' comp. We're kind of zeroed in on this. So when you talk about elder law, we'll give you that definition. I won't bore you with my resume, but This is all we've been doing. So when you get into it, folks will say, what is an estate planning attorney? And the idea is you have to understand the issues, and then you have to be willing to advocate for the issues. And that's the biggest thing. My goal is when somebody comes in the office is to listen to you, and we ask a lot of nosy questions when we do that. So we have to, and it's all confidential, but we have to ask a lot of questions about the family. That's not financial, but it's very important to your plan, gets in line with what they were talking about with stewardship and such. You have to have that nucleus of folks that are willing to help you or able to help you. So we talk about the family. We do talk about the assets. I'm not Monica. I can't help you grow the estate, and I don't have those licenses. It's not my expertise, but we need to see what you have so we can see what you can't live without. So we have to go through those type of conversations in pretty good detail. And then we have to talk about your health, and that's a big part of elder law. What happens at the end of the journey? When we slow down a little bit, what are our plans for that? So we're constantly asking about family health and stuff. Sometimes folks say, Chris, I'm not here to tell you how my kid's marriage is going and what the grandchildren are doing, but it's pretty important to get to know you so we know what your goals are and what your plan is. Now, they are nosy questions. And when you're going through the nosy questions in the office, what we can usually do is I can pat you on the back because I see you won the race. The house is paid for. More than just Social Security is helping you through the day. You have a nice nest egg, and you're debt-free. And honestly, you should pat yourselves on the back because what we've started to notice is this. You're that first generation to retire en masse with stuff. You don't spend money you have, let alone money you don't have. So you're the folks who taught us how to make it, and there's lessons there. But unfortunately, you're also becoming the folks that are teaching us how to keep it. So that's what we try to focus on, not gathering so much more stuff at your life stage, but how do I just keep what I already have? How does that seem so hard and important? And it is important because it is your nest egg. Now, what we did was we said, okay, well, first thing we have to identify to help you is, well, who wants your stuff? Who's looking for your stuff now or after you pass away? So what we did was we kind of identified that, and I've narrowed it down to a fancy legal concept we call the three rascals. These are the three folks we see if you get older, if you have an illness, or after you pass away, want a portion of your estate. And we're going to work through all three of those rascals in one way or another with these slides today. Monica's going to help me out a little bit because the first rascal we worry about is taxes. And there's a lot of different types of taxes. I'll let Monica cover that. Everything from death taxes to medical taxes to taxes when you want to sell something. But we have to be aware of those taxes so you can manage them. The next part of this is, how do we efficiently transfer the estate to the next generation? That's a big part of this. Nothing good happens in court. So we try to avoid court contact more and more nowadays because to us attorneys, believe it or not, we'd love to have a portion of your estate too. Don't volunteer it to us. Make sure you kind of keep things out of court system. And the third thing is long-term care. And that's maybe the thing that our clients are least prepared for is long-term care. They understand some of these death taxes, but they're completely lost if somebody gets sick. So what are our options there? So those are the three things we kind of build our practice on, and we try to walk you through as we work through what your goals are. So we're going to touch upon all this from some asset protection, disability or special needs, that's important, Medicaid veterans benefits, and Medicaid estate recovery. So on this side, it's really, what we're trying to handle, and on this side, we're talking about the tools we use to get there. And we'll talk about making sure you use the proper tools to solve the goal. So that's a big part of planning, and don't be bashful with your advisors. Make sure they ask the right questions and you provide the information. Now, this is a pretty big thing because a lot of folks will come to us at different life stages. We have folks that are, newly married, newly retired, third stage of retirement, slowing down a little bit. And they'll say, Chris, I was sent to you because you say elder law, and you're certified in elder law. What is elder law? Well, let me kind of give you my definition. I think historically you can actually give attorneys a little bit of credit. We've been very helpful managing things when you pass away. So efficiently transferring the estate to the next generation, watching taxes and all that stuff. But what we haven't been so good at is helping you, if you slow down a bit, before you pass away. So when the clients would come in and they say, Chris, I've got a medical expense, I have long-term care, how do we afford $10,000 a month, what options are out there, what programs are out there? Honestly, we were probably just as lost as you were. So elder law grew out of that simple concept. What happens if I slow down a bit or I stub my toe before I pass away? But we are built on that larger idea of law that everybody knows as estate planning, and we're going to talk a lot about that, of course. And you know, it's not rocket science, and you ask your advisors a lot of questions, and you should. And what your estate plan is this: it's managing all of your stuff. You know, what is my estate? What's your house? It's your car, it's your stock, it's your bond, it's your grandfather clock. Anything you spend a lifetime to acquire, we have to consider your estate for court purposes, tax purposes. Now we find out medical purposes as well. So that's what the estate is, and we have to have a plan together, and these are some of the tools we use that we're going to talk about in a moment that kind of achieve the goals of that plan. So we walk through that with the clients. Now the next thing is, you know, what's the marriage? Why are me and Monica here together? Because we work closely together, and it's a need. Your assets and the tools you use to protect them kind of go hand in hand. And there was a time when we weren't on the same page. You know, we're talking about something like a beneficiary, and the financial guys didn't know what the heck we were talking about because they're worried about the market and the stock and all that stuff. So I think we've kind of come more and more together, and that's why you'll see your financial guys send you to attorneys and back and forth, because I can put the tools in place, and sometimes that's the easy job. You're going to see these same tools pop up on these slides: wills, power of attorneys, trusts. So we're not reinventing a wheel. They're important tools. But I say Monica's got the hard part because she's got to teach us how to use them. I say she's got the practical side of the plan, because what she'll tell you, if you don't use these tools correctly, you're not getting any benefit. I review a lot of trusts, and they might be wonderfully drafted documents. I can't do any better. And then I say, okay, before I let you go, let me see the deed to your house. And it still says, you know, Tim and Mary, not Tim and Mary Family Trust. I say, if you walk outside and get squished by that school bus, that trust is not holding that house. You're going to have to take that will as a safety net and go through the probate process. Oh, no, we have a trust. Yeah, but you're not using it. It's an empty box. So you have to use these tools. And if you don't use them, then it can be a heartache, and that's why we hang out together. So your advisors will always send you back to your financial guys after we draft certain tools or recommend something like a beneficiary, and they'll sit there and make sure everything's kind of titled correctly. Because the biggest mistake we see, and we're going to go through this, that people make with their assets is not the investment strategies, but how things are titled. At least that's us on the legal side. So we'll walk you through that. Now, the next thing is the toolbox. You know, yes, you have to have more than one tool to get the job done. You can have a $500 hammer. It's not going to solve that board. That's why you hear stories, well, if I have a trust, why do I need a will? Don't the trust and the will do the same thing? And they do. Except the will, they're both designed to get the stuff to the family. But the will has to go through the court process. Probate, that's time and expense, and not always pleasant. The trust doesn't. So over the years, we've kind of looked over here at this line and said, that seems to be moving a little quicker. What's the advantage? But even folks that go the route of trust have a will. They'll have beneficiaries on IRAs, especially for tax considerations. They'll have powers of attorney as a safety net, because power of attorney trustee doesn't handle your health care decisions. So make sure you have more than one tool to get the job done, and that's what we're going to dive into right now, all these tools, and specifically why do you have them, and what did they do for you. So the first tool that we hear so much about, it's been around all of our lifetimes, is the will. And it is the foundation of your plan. Again, even if you go the route of trust or something, you want to have a will. What is a will? It's just a piece of paper. It's a statement of your intentions. Who's in charge, where things go, where things don't go. You have to state your intentions. Nothing's assumed anymore, so we want to put it down in writing. The will has to be in writing. It has to be witnessed. Better getting it notarized as well in Ohio. That law is getting ready to change. But right now, just 2 witnesses. Have to know what you're doing, be competent to do it, be 18. So it's a pretty standard document. Now, of course, we use your will when you pass away. We try to minimize that because what is the will? It's probate, time, and expense. So I try to say, let's have the will, but let's try and shrink it down. I don't want you to rely on that because that's going to be a little tougher situation. But we always want to have a will, even though we're trying to minimize court contact. I use your will as much during your lifetime as I do when you pass away. Unfortunately, when you say elder law, I'm dealing with a lot of older folks and folks that may not be able to speak for themselves. So I've got the healthy spouse, I've got the child in the office, and we're putting the plan together. But they can't speak for themselves, so I say, let me see the will. You know, if the will says the house goes to all 3, the house goes to all 3. So if one of those children says, hey, Chris, I'm the favorite, I'm supposed to get that house when mom passes away, I said, well, until that will is changed, and I don't think she can change it right now, it's going to all 3. So we use it again as a statement of your intentions, kind of a roadmap. It's another idea of what your wishes are. So you want to have a will, but you don't really want to use it. You want to keep that in the toolbox for a rainy day, and because that's probate, we're trying to minimize court contact, be a little more efficient. Court doesn't handle your affairs very well, and we're going to talk about this in a second. It also doesn't handle your health very well. But you still want to have a will, even if you do other documents. The next is the medical planning. Now, these are the powers of attorney. These are not assumed anymore either, and they're very specific. In 2012, we had the Uniform Power of Attorney Act, and basically we simplified things, we clarified things, but we also created 3 separate documents, and these are the 2 healthcare documents we created. If you have an older power of attorney, maybe from the 80s, 90s, 07 or something, it might be 1 document, 1 paragraph, and you say, well, I think I can do this, I probably want you to do that, we should be able to do that. Nothing's assumed anymore. You have to be very detailed. Most of the healthcare power of attorneys are statutory. That's why you'll see like the Ohio seals on the bottom and the Attorney General and all that. We use those same forms. We don't want to get too fancy for our own good. I don't want your physicians confused by them. I want them to pick it up, put it down, and know they can get the job done. They don't have to send it upstairs for any questions. So let me kind of walk you through these a little more specific. The first one is the power of attorney for medical purposes. It's called the durable power of attorney. Durable power of attorney for healthcare. The healthcare language is pretty understandable. Hospitals, doctors, HIPAA, anatomical gifting, discharge, any conversation with the nurse or doctor, I want my loved one to be able to have. That's very comfortable, and that's why people have it. They're comfortable with it. Now, when we get down to the bottom of the document, that's where you see the words durable. Durable is just fancy language that says this. This document will survive my incapacity. It's going to keep going when those 2 doctors are picking on me. So the standard of incapacity in Ohio is two doctors are picking on you. They say, Chris, you cannot make a good or bad decision. So when that hits, that means I need help. But if that durable language isn't in there, that document is expired, right? So what good is it? So it seems silly. I won't bore you with the reason for it, but you want to make sure the healthcare power of attorney is durable because you want it to keep going even after those doctors are picking on you because you'll get some use. I mean, think about it. I don't want anybody to make a major decision for me until I can't, but if durable isn't in there, the document expires. I'm not here to scare you. I'm surprised now after the years, 10 years now, if I don't see durable, but we still sometimes don't see it, so dust it off, have your advisors put some eyes on it, just double check it, because you want to make sure it can get the job done. So the healthcare power of attorney is hospitals, doctors, HIPAA, anatomical gifting, all of that. Second one is the living will. That's another healthcare document. That is a separate document in Ohio. In the old days, it was kind of built in, and it still is in Kentucky, but in Ohio, it's a whole separate document. That's the document when you're going through a St. for a procedure or something, they'll go ahead and print one out and give you a copy. I'm not opposed to them giving you that copy. We're using the same form because, again, it's statutory and it's very sensitive. You don't want to tinker with it if you're able because it's hospitals, doctors, hydration, nutrition, end-of-life stages. Any conversation with the nurse or doctor, I want my loved one to be able to have for me. Again, if you don't have that document, you're in court through a guardianship procedure. You don't want the court making your end-of-life care decisions. You'd rather have your loved one do it. It's not a perfect document. Cheryl knows this, sitting with some folks from hospice and such. We hear from the families what's done and what's not done and what trouble they had. We'll still say you're better served with it than without it. Now, all of these documents that we talk about are called springing powers. So if you list your spouse and then you stretch it to your children, don't worry. The children don't get to boss you around the second after you execute the document. They don't leap into action until you say, get to work, I need your help. Or 2 doctors are picking on you and say, get to work, Chris, need your help. So it's always you first, them second, especially with the financial side. There's a checks and balance system. So you have it in the drawer for a rainy day, but you want to make sure you have it when you do need help. We don't want to be tied up in court. So they are springing powers. So those are the 2 healthcare documents becoming very typical. I think I'm almost surprised when people don't have this, but I know some folks are still a little concerned about having them. But even if you do nothing else, make sure you have your powers of attorney. It was a miserable year or 2 ago, and everybody's caught off guard, unexpected illnesses, locked away like we never thought, and not having that document was very difficult. So have the healthcare power of attorneys. The next power of attorney is a financial power of attorney. That is a separate document. Like I said, in the old days, it was built in. It's a very detailed document. We would call them general power of attorneys, financial power of attorneys, business powers of attorneys, fiduciary powers, whatever they want to say, but it's a very detailed document. Monica will tell you this, but our financial power of attorney is about 8 or 9 pages long, and it's not long enough. One bank wants you to say this, another financial institution wants you to say that, and you can't argue with them in the wrong time. You're in a crisis. You need to just get the job done. So make sure you have the right language in it. It's pretty detailed. These documents are very sensitive. Of course, you're giving someone the ability to help you or make financial decisions. I say it helps you keep the lights on. It allows you to sell property, call banks, deal with beneficiaries, write checks, pay mortgages, call the insurance company. So any business transaction you need to get done, make sure you kind of see it in that document somewhere. But they're becoming very important. Those are the ones I think, Monica, that most people don't have. If I see a packet, that's when it's a newer document, and they weren't around forever, but check that with your advisors. Sometimes the bigger financial companies like Monica, they draft them for you. They have forms. Everybody's a little different, but just make sure you have it. Now they're practical documents, the healthcare and the financial document. I mean, they're tools. We got to ding them up and dirty them up at times. They don't just sit in the drawer forever. So make sure you know they're there, and make sure your advisors know they're there. We have children that don't know what the heck mom and dad did, and they might have all the documents necessary, just can't find them, or didn't know they had them, and they're scrambling around. So what I'll tell them, and Monica, you can tell me if I'm wrong, but I'll say, you keep the originals. Hardly anybody needs the original. I mean, you better call your advisor before you hand over the original. That's our philosophy. Copy, copy, copy. I don't care how many copies, how old the copy is. We email them all the time nowadays, right? She'll tell you so. I'm right there. So you keep the originals, copies suffice. But make sure your advisors know about it. So I'll say, give Monica a copy. Let her send it upstairs and have the guys look at it, review it. And if they approve it, she'll put it in your file. Same thing at the bank. Now give them copies. It doesn't mean your son or daughter is going to get to work tomorrow, but you've had the bank review it, and if they do need it, it's already past that step and it's on file, it's approved, so you can get the job done. Give them to your physicians, so they know you have them. We're calling physicians all the time asking about it if it's in their file. So make them known, again, so folks know they're practical documents. Give them to your children if you're comfortable. Let them keep it in a safe place at their house. Now, how do the documents expire? There's a few things. If you don't have enough language, that's why I keep saying have somebody look at it if they're older. Another way they expire is when you say so. You give the power. You can take it back in writing at any time. You can revoke it, so it's nothing set in stone. Another way it expires, we just saw this with a friend who passed away. They had their spouse as the agent, and that was it. He recently passed away, so that document expired. So we want to make sure you have your spouse if able. Then you have hopefully your adult children if you're trustworthy and are responsible. Keep the line of successors moving because we need them to be there when necessary. So it expires when you say so. They expire if you don't have the right words. They expire if you don't have enough help. And this is frustrating. It also expires when you pass away. That's very confusing to folks. We just had last week a person, an angry son from the bank call us and say, Chris, I want to put the teller on the phone and you go ahead and give her to what for? I said, what's going on? He said, I'm here trying to settle the last few bills for mom's estate. They won't even look at me. He'd been going there for 2.5 years, taking care of mom's affairs as a power of attorney. I said, well, I can't yell at her. She's actually right. When mom passed away, your power as a power of attorney expired and went with her. Now, what's frustrating is she wants her son to help her with things after she passes away, just like he was doing during her lifetime. But now we got to get the bank some new paperwork. Is he the survivor? Is he the beneficiary? Is he a fiduciary? Is he an owner? Is he a trustee? Is he going to be the executor? How is he going to get a new title to start managing that account? And that's what's frustrating. Same person most often, same responsibility, they just need new paperwork. So we try to brace you if we know ahead of time, but the power of attorneys do expire when you pass away. Now here's some good news. They don't expire when you leave Ohio. So if you go down south for a few months, take a copy with you. If it was done correctly in Ohio, South Carolina, Florida, Tennessee, they're going to recognize it, all right? So they do travel with you. You don't have to have a document in each state you go to. So these are very practical, and Monica, I know you use them all the time, and want to make sure you have them. Not having them is a worst-case scenario. Real quick story, we had a person 2 years ago that we were doing some Medicaid planning for. Dad's in the nursing home, mom's in the office. I'm going through those nosy questions I mentioned. And the first thing I said was, you get to stay in the house. We can argue with Ohio, you need a place to live. So after the conversation, I said, let's get to work. So to get that exemption of her staying in the house, we need to transfer the house from him and her to just her. He couldn't sign. So I said, let me see the power of attorney. She didn't have it. She had the health care, but not the financial. And our heart sank, and I said, we're stuck. And this is where I kind of put my foot in the mouth. I said, we're not going to get that exemption. And the son said, why? I said, because Dad didn't give Mom permission to transfer the house. We don't have that power of attorney. She said, Chris, I've been married for 52 years. Don't tell me I need his permission. I said, to make this transfer and record the deed, we do. So we're stuck with his name on the house. When I apply, Ohio's going to say, oh, good, it's our house now, right? Sell it and give us a portion. So please, that's how important these documents are. Have them. I mean, we use them all day long. First thing we ask for in many cases, because again, we need them to get the job done. So power of attorneys and wills are your first line of defense. State your intention, give responsibility to loved ones so you can get the job done.
Should they be in this state or does it matter?
What I'll say there is health care, they'll work if it was done correctly in Tennessee, but they're so state specific. I'm not saying the Tennessee document won't work, but I'd rather have you just get the Ohio if you can, so again, they can look at it and put it aside. The financial documents are more transferable because very few banks are in Ohio anyway, and you're dealing with, other New Jersey and Boston and all that stuff. So I would say if you're going to move, update the health care or have them reviewed.
What about us having somebody in another state?
That's fine. It's your plan. Yeah, as long as they're available and you're comfortable with it. If they live in St. Louis and you say, hey, they answer their phone, check their email, they're on, yeah, that's fine. Now, if you go through the court, they have to be a resident of Ohio. But your plan is different than the court's plan. Okay? So your agents can be out of state. And we'll say name the most responsible. We like to divide and conquer sometimes. One child's pretty good with the monies, the other child has a bedside manner. So one's on health, one's on financial. You can put them on everything together. We have conversations, we talk about the pros and cons. Can it be too many cooks in the kitchen? Somebody's not available in a crisis, but we prefer successors available, 1, 2, 3. It's a labor of love. They don't gain anything for it. They just get to be the one to kind of deliver the news. But at least if you have 1, 2, I mean, it's half the battle. Yes, ma'am.
Now, you said the gentleman was in the nursing home, and his wife is gonna have to sell her house, and it's because she didn't have a power of attorney from her husband?
Yeah, because what the state will say is that one of her exempt resources, we'll get to that, is the house. But to claim that exemption, she's got to transfer the house to her. It's allowing the husband to gift it to her. If he can't sign and he doesn't have the power to do it, we can't complete that transfer. So when we show up at the application, Ohio says, okay, you got a year to make that transfer. And if we don't make that transfer by the end of the year, they say, okay, he's over resources based on his interest in the house. So you got to sell it and mortgage it or get them their interest.
And that's because he was in a.
He wasn't able to sign, wasn't competent. Yeah, it could be at home. Wasn't competent, she didn't have the power of attorney to sign. He didn't give her permission to transfer. It's frustrating. That's why we say, hey, I don't care where you get them. I don't care if you print them off the internet. I don't care if Susie Orman brings it over personally. We don't make our living drafting them. We make our living using them or you not having them. So you want to have those documents. They're accessible, inexpensive. Get them, all right? All right. So the next thing we worry about is those are some of the main tools, wills and power of attorneys, and then we talk about the court system, and the court is, the probate court, it seems like a mystery, and it seems necessary. In the old days, we told you the only option, and it might have been true, honestly, we had a lot of advancements, but the only option we had was to open an estate, present the will. But nowadays, you don't have to present the will in most cases. You don't have to open an estate. And a big part of that is minimizing the need for probate. Nothing good happens in court. Spend a lifetime avoiding it. Why are we volunteering our families to it after we pass away? So we're trying to make things a little more efficient for them for a lot of reasons. We have to, or it just makes sense. Now, I'll talk about ways to avoid probate, but folks will say, what is probate? And it's not what you see on TV. It's not a lot of grandstanding and a lot of fancy arguments. It's paperwork. That's why it's such a mystery. And you're not even there. You're just sending the paperwork back to the attorney, and he or she's sending it in, and there's a lot of wait periods involved because everybody else's interest comes before you. The creditors have to be satisfied before the family. The IRS has to be satisfied before the family. You know, arguments have to be settled before the family. So we're trying to, again, minimize court contact. Now, what's a good definition of probate? It's not rocket science. It doesn't help or hurt you for taxes. You have to plan for taxes during your lifetime. And it doesn't care what the family does with it. It says, all right, here it is, good luck. And if they drive too fast, have a disability, there it goes. So you have to plan for that during your lifetime as well. So probate really whittles down to this. It becomes nothing more than a court-supervised way to retitle an asset. You're going through all those months and paperwork for a piece of paper from the judge called a certificate of transfer, where they finally give you permission to swap names. All right, we can take my name off the house, get my wife on, or keep it there. She passes, the boys go back to court, repeat the process, and get permission to take her name off and put theirs there. Seems silly, right? Seems pretty simple. So why don't we go ahead and beat them to the punch? And that's what we'll talk about now. So this is the biggest thing, is how do we avoid probate? These are the most typical methods up here. There are other methods, but let me kind of laundry list what I talk about in the office most often. First thing is beneficiaries. Beneficiaries are pay on death, transfer on death, dated death, all the PODs, TODs, DDTs. Banks call them something different than the insurance companies, but it's paperwork. It's a contract. It's a contract with whatever institution holds your stuff. And it tells them what to do with your stuff after you pass away. So I can go down to the bank, me and my spouse, we fill out all the paperwork and say, pay on death to you, pay on death to the 2 children. I like that because you can have a beneficiary, Monica will go through this, on almost any type of financial account out there. Very important on IRAs and stuff like that nowadays. So beneficiaries, and we can even have beneficiary type arrangements on your property. We have a transfer on death affidavit on the home. Not all states have it, Kentucky doesn't. So you can almost pay or transfer on death your entire estate to the next generation. So even if your will says leave everything to Mickey Mouse, we'll talk about that in a second. I'll give the answer where I almost did that. So we'll see what's more important, the will or the beneficiaries. But make sure you have your beneficiaries in order, all right? And that's something the numbers guys really help with nowadays. The bankers are very in tune with it. Make sure you have your successors. Now, the biggest mistake I see with beneficiaries is they're not updated. Yeah, I only had 2 grandchildren when you first did it. Now you got 5, and they're not even mentioned. We see some folks that either somebody passes away, don't update some, somebody goes through a divorce and doesn't update it. And that's, again, why I say watch how things are titled. Monica's shaking her head. She doesn't want those phone calls. We had a client come in right at the end of last year. He was referred to us from the nursing home, in there for his spouse. And it was a heartbreaker. We're going through all the nosy questions again, the resources. And we identified a $100,000 account, and he never really mentioned. And I said, well, what is his account? He goes, oh, don't worry about that. That's my son's life insurance policy. He worked for Cintas for 23 years, started right out of college, and he had an illness, passed away, and guess who were the beneficiaries? Mom and Dad. He didn't update it after he set that policy up, right? He's married now with 2 kids. Guess who wants that $100,000? Ohio. Mom's in a nursing home. We're wrestling it away for the wife and the 2 kids, all because he didn't fill out paperwork. So again, I know it's busy work, and when you sit with Monica, you're going to pick on her about the interest rates and what the stock market's doing and who the new president is or isn't. But don't forget to talk about how things are titled, because we see it, okay? So beneficiaries are extremely important. Did I read the question or just pop it up? You can do that. Okay. So beneficiaries are important, and this is why. So let's say you have a will, and your will says leave everything to Mickey Mouse, but your beneficiaries leave everything to my 2 children. What works? What trumps? The will or the beneficiaries? Yeah, so the beneficiaries trump the will. So you want to make sure they're in order. We had someone make a very fancy, sophisticated changes in his will. And I said, we got to sit with Monica because we got to mirror that on beneficiaries. So make sure they coordinate. So that's important. All right, let me go back to the other slide real quick to finish up here. So other ways to avoid probate. We have beneficiaries. Next thing is we have survivorship, ownership. Now survivorship is what we call ownership because it's not fancy. It's not a tenancy or a use. It's equal shares of the whole. You can have survivorship on most financial accounts except for IRAs, and we have it on property. So let me define property. So let's say I have a deed with my wife, and it says joint tenancies right of survivorship. We each own 100% of that house, no more, no less, equal footing. I walk outside, I get squished by the school bus. She's the sole survivor, sole owner. She now owns 100% by herself. We don't need the probate court to add or subtract. Her name's already on that account or that deed. That controls. So I like ownership with your spouse. Monica's going to talk about this, but be careful with ownership with the children. I love my kids. They're angels. They walk on water, but accidents happen to the best of us. So it's a liability worry. And Monica would get mad at me for doing it because you got a tax problem, right? Capital gains and such. So don't overdo it. I mean, don't stretch that rubber band. So I like ownership with the spouse. Always talk to your financial guys before you talk about ownership with the children. It could be a liability or a tax worry. The next way we use for probate avoidance is gifting strategies. Monica will talk about that. That has a purpose in planning, but know why you're gifting. My philosophy is you gift because you want to, not because you think you have to. But if you're gifting from a planning perspective, you need to talk to us. And the reason being is there's laws associated, and the laws are confused, but very different. Everybody knows the gifting laws in regards to taxes, the old $10,000 a year rule and all of that. But on our perspective, that has nothing to do with nursing homes. So we've had folks say, oh yeah, you can gift a large amount away because you're not going to have a tax problem. But then I said, uh-oh, you gave it away within the last 5 years, so the IRS isn't mad, but the state wants it back because now you got a nursing home problem. So I look at gifting from a long-term care perspective. What happens if you get sick? And we're going to talk about that in a second. Monica looks at it from a taxes, but gifting is an option. So those are some of the most typical ways to minimize or avoid probate. There we give that answer. All right, the last thing, I think, before one of the last things is trust. Now, I won't bore you to death with trusts. Trusts have been around as long as wills. The confusing thing is there's as many types of trusts as cars in a parking lot, and they do almost the same thing. Basically, all trusts are a shoebox, a place to hold things. And you want that box in your name, your social security number. It's always you first, family second. So you're the boss. Bank where you bank, shop where you shop. You're the manager, the trustee. You have access. You're the beneficiary. You enjoy it now. Children, family will enjoy it down the road. Why do folks have trusts? One is probate avoidance. I say, hey, when I pass away, that box stays on the kitchen table. It survives me. My oldest son would be the next manager. He has access, but he's not tied up into court for that access. One is it preaches patience, so it helps you with liability and taxes. And then you can have a lot of fancy language in the trust if you worry about taxes. So we use it to control distribution because you want to protect the family. It's a place to hold things, whether they're too young, spend too much money, have a disability. We use it to keep an eye on taxes because they preach patience, and we use it as another way to avoid probate if necessary. Now, when you're first starting this type of planning, most folks are talking about revocable trusts. And revocable trusts are very good for probate, family, and taxes. But revocable does not protect us from long-term care because revocable means there's no lid on that box, right? Get into it on Monday, get into it on Tuesday to pay the nursing home. So we had to come back to the drawing board about 18 years ago, and we added irrevocable language. Now, irrevocable is a big word that means you can't do something. And without boring you to death, all it's saying is that you're still the boss, but you're willing to give up some responsibility. The language says you have to have the assistance of another. We call them helpers and protectors. So with the irrevocable language, it requires your son or daughter's help to get that asset out. Now, if they don't behave or they're not agreeable, you can remove them and name another helper. But the state of Ohio can't do that or fix the problem. So when the state of Ohio tells that family to sell the house, it allows us to say no to them. It's not their trust, they're not the boss. They can't move all the parts around to force you to bring it out. So in simple terms, what the language of the trust does is it makes it unavailable to Ohio. Unavailable is that magic word that gets that 5 years ticking. I know we've all heard of the 5 years. I'm going to talk about that next. So it's a way to keep the asset in your name for tax and liability protection, but with some assistance from the family, that irrevocable language, get that 5 years clicking in case you get sick. If you never get sick, we still avoid probate and all that. If we get sick, we're hopefully far enough down the road that it's not part of their review. So a lot of folks will have trusts. They start revocable, and then when they get to that next stage, they become irrevocable. Now, many trusts become irrevocable at death, so no one else can change it. It's a place to hold things for others, no matter what the concern is. Now, this is something Monica can talk about, because again, folks have trusts, but they don't know how to use them. And we use them different in health than we do in crisis. First thing, we have to make sure we use them. So Monica's of the world make sure we've got things titled, funded, named to the trust. But we might start slowly and say, okay, you know, if we're just getting a little older and a little worried about long-term care, maybe we put something like the house or insurance over there. And we usually start there because that's not what you're spending on retirement. You don't cash in the house to go on vacation. The insurance is on death. And I don't want you to feel like you have to call that son or daughter to go to the grocery store. So that's a good place to start. But as you might get older, as the medical issues are getting bigger, the expenses are coming closer, then we'll say, okay, let's pour things into the trust. Let's kind of, you know, shift that balance a bit depending on where you are. So you want to make sure you use the trust. If you're using it for minors, you can set certain assets aside for that. Using it for children with disabilities, there's ways to fund it specifically for that. That's, I think, where your advisors kind of get a black eye. We draft the documents and don't help you with them. You don't want to be afraid of your advisors. You want to use these documents. Now, I think this is one of the last things I'll talk about is the asset protection and long-term care for Monica starts here. But it's a three-part test is what we're saying. You know, if you're asking the state for help, it's a needs-based program. And basically, there's three things they look at. Do you have a medical need? Unfortunately, are you sick enough? Second thing is, do you have an income need? Well, that's easy because most of us don't have $12,000 a month to pay the nursing home, even on fixed income. Third thing is, do you have too many resources? Now, that's the one where we have to kind of go through the hoops on because they think you don't need more than $2,000. If you have over $2,000, they don't think you have a financial need. So we have to learn, we have to use these tools like trust and gifting and whatever else we're doing to make you resource eligible. All righty? That's what we'll walk through now. So when we look at financial eligibility, I have folks that come in and their head spinning and their brother-in-law told them this, their beautician that, their banker, and they say there's insurance guy. How is this so confusing? Well, when you get to this type of planning, long-term care planning, it depends. It depends on multiple factors. I better ask as many questions about the healthy spouse as I do about the person in the nursing home. That's a planning opportunity. I need to see what the children can do for you or not do for you. That's a planning opportunity. And again, we need to see what you have so we can argue with Ohio, which you can't live without. If your advisors don't click through all three of those areas in pretty good detail, you're missing your deductions. You don't want to miss your tax deductions. You don't want to miss your medical deductions. And most of your medical deductions are in the family. We talked about the spouse. So if you have a healthy spouse, it's called the Community Spouse Resource Allowance. There's assets that we can provide for the healthy spouse: a place to live, a car, up to $150,000 in liquid assets without question. Their income plus a portion of the spouse's income. A little bit of insurance, especially if it's designed for burial, and all the personal property. And now Monica would tell you if you start treating the IRAs a little bit more like a pension, those can be exempt as well. So there's a lot of assets we can keep. I'll go through that resource assessment and say, okay, out of all this stuff, here's what's exempt, here's what they want you to spend. And that's a pretty good exercise. Now, if I don't have a spouse, I'm looking to the kids. And these are things your advisors should be focusing on. Do you have minors? Do you have dependents? Do you have children with disabilities? All ways to fund that trust without penalty. So that's a good thing. Now, what if this? If you have a child care provider, someone who's living with you providing care, well, we can get awarded the house because of that care they provided. So there's some pretty big deductions out there. That's why you want to make sure your advisors are really clicking through them. So the next thing is, after we work through that exercise, what's still left on the railroad track? Is it 100,000, 200,000? We had a vacation home in Florida today that was going to be part of the spend down. Now, when we identify what's part of spend down, that's when we get back to the trust. We say, all right, let's use it. Let's start filling it up. Now, when we fill it up, that's where that 5 years comes to play. Have you guys heard of the 5 years? It's not 7 or 3, it's 5. Everybody looks at the 5 years like a punishment period. It's not. Doesn't matter who you are and what you do, everybody who goes to Ohio and asks for help is put through the 5-year audit. It's called the look back. It simply gives them the right to look back for 5 years and say, where's that house, car, money? Why do we have to chip in? They don't want to pay the bill any more than us. And if you put something in that trust within 5 years, they have the right to penalize us. That's the secret sauce. Nobody knows what these formulas are. Nobody knows what these penalties are. They're buried in the statute. They don't like me to tell you. We work them through in the office. So we say, all right, let's figure out how much we can put into that trust. It's usually about half. But because that's happening within the last 5 years, it's subject to penalties. Here's the consequence, the months of ineligibility. So we need the other portion to pay through those months. So it's usually a gifting and a spending strategy. If you look on the computer, I'll leave you with this, you'll see the attorneys talking about a rule of halves. What we're trying to say is, even in the worst case scenario, We can use these tools we all talked about and protect about half the value of the estate. That's with somebody in the nursing home, not doing anything 5 minutes ago, not really doing any planning before they sit down with an advisor. So don't quit on us if you didn't do it 5 years ago. That's our biggest frustration. You're constantly told if you didn't do it 5 years ago, you don't have options. You do. Nothing could be more from the truth. You can do a lot more 5 years ago, but don't quit on us if you get caught unexpected. That's how we have to know how to use these tools. Monica will help me with that.
Very informative, and you probably feel like your head's about to explode, right? So we're going to have a pop quiz. Does adding beneficiaries to an account ensure that you bypass probate?
No.
It does. For that particular account, not for everything else, but just for that account. Okay. As long as you have an attorney create a trust for you, then your entire estate bypasses probate. You think that's true or false? False. That's right. So remember, just having the trust isn't enough. Trust is like a box, and you need to put things into the trust in order to bypass probate. Everybody needs a trust. True or false? False. Not everybody needs a trust. And that's part of the discovery process that you go through with someone like Chris, is sitting down, talking about what your needs are and whether that's something that would be for you or not. Okay, so one of the things that you need to keep in mind is that we live in a very digital world, and people oftentimes forget that certain things, once you no longer have access to them, that they are, you can't do anything with them. So for example, a friend of mine, her mom really loved Facebook, and we still get reminders on Facebook for her birthday and things like that, and there's no way for her to turn that off. So it's nice to be able to think about your digital life, and you want to kind of protect your digital life. So there might be things like pictures, music, video, your Facebook account. You might have digital assets, cryptocurrency, or NFTs, which most people don't know what those are, but things that you own in the digital sphere that are valuable, and you may want to make sure that you have those protected, and that you at least your relatives know, where they are. So a lot of people don't like to kind of give up that information to their children, especially while they're around. They might want to keep some of that information a secret until they've passed on. So one of the ways that you can do that is through something called Everplans. It's a secure digital archive where basically you can put all of your important information and documents on there, your will, your trust documents, your power of attorney, medical, financial power of attorney, information about, which bills get paid to whom, any kind of life insurance maybe that you have, your final wishes and your funeral preferences, that kind of thing. So all of this can be spelled out and listed in this Everplans, which is a secure online. So what happens is you're the primary person who is, I guess you could say, the owner of this account, and you can co-own it with your spouse, obviously. And then what you do is you name deputies, so that if for some reason you're no longer around, Everplans will try to contact your deputies. You set up a time frame, so it may be 24 hours, 72 hours a week, where maybe one of your deputies reports that you're no longer around, and they basically try to reach you for that period of time. If they cannot reach you for that period of time, they open the accounts up. So then they can see, you can even have like letters to them that you want, things that you want them to know. Password to specific things like, maybe not just your Facebook account, but how to work the remote control in the basement that nobody else knows how to use, or whatever the case might be. So if you want a free copy of that, there is a a sign-up sheet in the back by the dark blue table where you can get a free copy. We offer that. We purchase an entire program at Harvest, and basically we give them out like candy. So you're welcome to have them. All we need is your name and email address. We cannot see that information. It's completely private for you. But it does allow you to maybe not share all of your information until it's time. The other convenience is, let's say you have your medical power of attorney on there, or your living will, and you end up in the hospital, you can pull it up and electronically, send it to someone if you need to. So it gives you access during your lifetime as well. All right, so the other thing I wanted to mention, and maybe you want to talk about this a little bit, Chris, is that if you're thinking about, nobody likes to do estate planning because we don't want to admit that we're mortal. But if it is something that you want to pursue and you haven't done it yet, or you need to make sure that everything is updated, or your situation has changed, Chris would, be willing to sit down and meet with you one-on-one at kind of a discovery type meeting.
Yeah, it's confidential. You can bring in specific documents, specific questions. We'll give you all the information. We don't hide anything, and as a courtesy to the care committee, there's no cost for the consultation. So it's your idea. Like I said, I did throw a lot at you. If you want to talk about more specifics, I think Christy gave you some information, or we'll have her contact info.
Everyone's situation is different, so what one person may need, another person may not meet. You come up here, we're gonna do questions together. Probably primarily gonna be for you. Come on. What questions does everyone have? Not everyone at once, it's too overwhelming.
What would a cost example be to get the whole thing done?
That's a question for you, so what would a cost example be?
Yeah, I can't speak for others. A lot of attorneys will charge by the hour, the phone call, the year, the follow-up. We don't. We charge what we call project fees. And most of the attorneys that do that, it's from $2,500 to $3,500 for all the documents, wills, trust, power of attorney. Of course, if you don't need certain documents, it kind of lowers. It's just by package or what we draft. What we're proud of is our referral base, and we have an older client base, and they're struggling to get things done or get through that 5 years in many cases, so we don't want them afraid of us. So we don't charge them if they call us or make a change, but that's why we try and charge a flat fee.
And where would we need to go for this appointment?
You have a few different locations, don't you?
Yeah,
Do you
we
wanna
have an
step over
office.
here?
No, you're fine. I'm fine. It's we have an office, and close one here is Lavin, a couple exits away. Down right next door to the Golden Lamb, have the building there on Mulberry Street. If you want to come closer to our house, it's in Fort Thomas, Kentucky, or we have one up in New Albany, but yeah, probably Lebanon office. And you meet with us, the attorneys, and again, we don't hide anything. We respect your time, and you may have simple questions or just researching things even.
And remember, don't just go and get these documents drawn up. Once they're drawn up, you need to also tie them to your assets, or tie them to, as beneficiaries in some cases, or re-register your home in trust. And I just have a little tip about that, if you don't mind. You want to make sure that if you re-register your home into your new trust, that you also contact your insurance company so that the insurance policy is also in the name of the trust, because a nightmare situation would be that they don't want to file a claim because the person who owns the policy is different from the person who owns the house, which is the trust, okay? So you just want to, it's a little bit of a trap. It doesn't cost anything to update that on your insurance policies.
Yeah, you stated primarily insured, and then you named the trust as the secondary insured.
Is there a minimum asset amount that is needed to get attorneys and financial planners involved, or?
There's not a minimum,
Monica,
well,
repeat the question.
okay. So is there a minimum amount that you would need to have in order to benefit from doing estate planning or do asset management? I would say that if you have assets, and most people have a home, right, cars, those kind of things, that there's definitely, and even if you don't have assets, there's the medical power of attorney, there's the financial power of attorney. the living will, am I
mean,
missing
guess-
anything
no,
there?
No. In the old days, you would hear, I don't have a gazillion dollars. I don't, well, that's not always important. You just plan differently based on what the estate is and what the goals are. So Monica's right. We may not have to do a lot of fancy tax planning or trust planning, but we need to have the will and power of attorneys.
Now, if you have more than 12 million, there might be some special things that you want to do to, you know, avoid some taxes, but most people fall under that category. But still, it's important
Well,
to
what
do that
folks
planning.
with smaller estates, like maybe the house, and that's every bit important to them. And
Yeah.
we'll do some trust planning with that 5-year rule in the house because, hey, we want to make sure we have use of the equity.
Mm-hmm.
Because again, let's say, going back to the couple again, let's say they did some planning, had the power of attorney. Well, we would get permission to transfer the house to the healthy spouse, right? But then let's say 2 years later, the healthy spouse wants to downsize and move in with their daughter. Ohio's not letting you keep the equity in the house, they're letting you keep a roof over your head. So I got to give them the good news, when you sell the house, Ohio's going to be at the front door looking for it. So if we can put it in the trust, get the clock going, then it's still exempt, but then they have options. So if they want to sell the house because it's too big, because mom or dad's not there, they can sell it. And they can do whatever they need to with the equity, what they thought they could do. So, yeah, I mean, it's just meet your goals is what the advisors should be doing. I don't care what tool they use to do it, but that's why they have to listen to you to meet those goals.
The financial planning and the attorney planning, they go hand in hand. Should you go to one first and then go to the other one, or does it really matter?
That's a good question. So he's saying the financial planning and the estate planning go hand in hand. Is there one you should go to first before the other? And I would say everybody kind of comes to it from their own
Yeah,
perspective.
it's not
Some
a
people
big difference,
would
right?
go to you first and get all that straightened out and then go to a financial advisor. And some people come to a financial advisor, we assess their situation and say, you really need to go talk to Chris because we have, you know, we're missing some estate planning documents here and we really need
Yeah,
those.
a lot of folks will start where they feel they have their biggest worries or concerns. Hey, I haven't really had anybody look at the financial store. My mom or dad just passed away and we spent 3 months in probate and I gotta go see somebody about that. But it does kind of bounce off of each other. I always say, you know, you need to build a network of advisors that you're comfortable with and they'll steer you in the right direction. So if you have a good relationship with your financial person, Monica will make sure she's looking at all assets for you, so she can send you somewhere if she needs to. Same with us, we'll send you to the Monicas and say, hey, she'll help us with this or that.
We'll get you both, don't worry. Who wants to go first?
I was just gonna say, I mean, I admit I'm very ignorant on a lot of this, so if this is a bigger question than what needs to be answered here, just tell me. With parents who just don't like dealing with this stuff,
Mm-hmm.
and not sure what all they have, if anything, and they don't really know where it's at, what shoebox somewhere or something. If they were both to die tomorrow, it would go to probate, it sounds like, which isn't really a place, but it's a system.
You would have to go through so what you're asking is, what would happen if the parents don't really take care of,
Right.
you know, planning, and they suddenly both pass away? Would that go through probate? The likelihood is that yes, because they haven't planned, and then, you know, it's the court's job to figure out who gets the assets. And then it's gonna follow by law, not necessarily by the preference of the people who have passed away. So it's better to plan ahead of time. And it can actually impact you, if you don't mind me going down this little avenue. It can actually impact you even if you're still alive and you're incapacitated for some reason. So, for example, let's say somebody has an aneurysm and they can't speak for themselves anymore and they didn't go get any power of attorney paperwork for financial or for health care. Well, for the health care, they would rely on the next of kin initially, but then the next of kin can't necessarily pay bills and things like that. So it kind of puts them, you know, in a position where they're pretty vulnerable, because they really need someone who can do things on their behalf, pay their bills, make sure the lights are still on at home and things like that. So it's important to get that taken care of ahead of time. So if you're in that situation, you have to go back and petition the courts, which is time consuming, right? And ask the courts to assign a power of attorney for you so that they can speak on your.
Second to the most important is the power of attorney and the power of.
Yeah,
Well-
because even if they don't want to do anything else, that gives you the ability to do it for them later. And then I like what the pastor said, about stewardship. This isn't for them, it's really for you. Makes your life a little easier. We just finished a plan around the holidays, and she said, hey, make 5 copies, Chris, and I made them, and I just said, interesting, why 5? She goes, I'm going to wrap them up and put them under the tree for my kids at Christmas, because this is going to benefit them, so.
So 5
I mean,
kids,
it's just-
Club Cinco.
Yeah, 5 presents. So.
What was your question? I know you were next.
What information and decisions do we need to make before we set up an appointment? What do we have to gather?
So let me repeat the
Yeah.
question. What information or decisions need to be made before you make an appointment with an estate planning attorney? Go ahead.
If I could talk from the attorney perspective, Monica mentioned what she would ask. I just say, I'm going to go through areas of your family, your health, and your stuff. And the more details you give me, the better off I am. If you have old legal documents, we'll look at that. Deeds, old wills, power of attorneys. We don't always start with the financial stuff until we get with the Monicas, but we kind of get a ballpark. You have a house, you have a little bit of money in IRAs, that landscape. And then really you got to illustrate what your goals are. What are you trying to accomplish? Are you scared to death about the courts? Are you worried because your long-term care, the doctors are picking on you? Do you want to control distribution to the children? And then it kind of leads us down the path we need to go. And you might want more details with things, but.
I think, for somebody who's setting up an appointment with me, the first thing we would start with is the assets, because we're, more financial focused. And then what my process is when I bring a new client on, we go through a full financial plan. And we're gonna touch all of the different areas of financial planning, including estate planning. And then I may, refer them off to somebody who can help them with estate planning documents like Chris. And then they would come back after those documents are completed, and we would assign them to the appropriate accounts, that kind of thing. Yeah, so it's a process.
Don, how long is the first appointment?
Ours is, we start with an hour and we can stretch it if needed, come back later, so to speak. But we want to make sure you understand what we're talking about and what we want you to do before you do it. Then and again, there's no retention until you say, yep, Chris, I think you can help us, you know what you're doing. Then we're pretty systematic from that point forward. Everybody in the office has an expertise, I'll say, so we kind of walk you through that. How they get the information for me to draft something and get you to the Monicas when we get the funding and all that. So it's a step by, it's not a full-time job, but I say we usually solve it in 2 or 3 meetings, honestly. Yeah.
And I would say too, from Chris's perspective, like what we went through today puts you leaps and bounds ahead of the game in terms of educating you on what it is that you need and some of the whys behind the importance of the documents. So you're already kind of somewhat educated before you even go in. But Chris's job is going to be to find out more about you and your personal situation and what's important to you and what your needs might be, right? Because everybody's a little
Yeah, we have
different.
to identify the needs, make sure we know the legal tools that get you there, and then our job is to know the tools inside and out. But when you buy a car, I don't look under the hood. They laugh at me. I don't know what's in there, but I know it looks good, comfortable, it gets me where I need to go, it solves the problem, right? It's kind of the same thing. Now, what we try to do is when we charge these flat fees, that's what we charge them, so you're not afraid of us. You call us with questions. Look at something on the internet. Your buddy said, well, does your trust have this? I get that out. Yeah, we've got this, or we've got this. I want to tinker with this. So don't be afraid of the documents. Just kind of know you've got them, and they're going to solve your problems, your worries.
Now, do you, I'm sorry I was late, because I know my mom died in 18.
Mhm.
She left my daughter be the power of attorney
Okay.
for, because she knew I'd be devastated. My daughter was in Denver, and it was a nightmare for her to handle the finances and everything else. It was trying to get,
Yeah.
because she's there, and everything's here.
Well, it's a labor of love. She didn't gain anything for it out in Denver. And logistically, it may have been a little tougher than, not being up the street or 2 exits away. In that case, you know, we have to respect mom's wishes and why she named the daughter, but then what she can do in most cases is name an independent advisor or trustee.
That's
So
what I was
say,
wondering.
all right, Chris.
Can you name your, or could you name a lawyer in lieu of your,
Or
I mean,
you
what
can name a,
options are
yeah,
there?
yeah, they're professionals, there's other family, financial advisors do it and say, hey, I just need you to kind of help me get this job done. Because it's a lot of paperwork even when you're not tied up in the court. I mean, Monica will tell you that, right?
It is.
We try to make it as systematic as possible, but it's paperwork.
I had somebody call me a couple weeks ago, and they said, we were talking about estate planning, and she said, oh, you know what, I'm gonna use Chris because when my parents passed away, everything was taken care of. And
our
it was
job.
so smooth, so.
Thank you for saying that. I
Yeah.
didn't tell her to say that, that's her
Well,
job. Thank you. Yeah, we try
She
to make
did,
it
he
as
did,
smooth
he
as
didn't
possible.
even know about this. Yes,
But it's-
ma'am.
My parents have a trust and I'm the executor. How does that play out as an executor? Can I go and get a copy of that because my mother has misplaced it?
Oh,
And I have no idea how everything's set up. I do know that they've allotted certain things for most of the grandchildren.
so what to do if you're the executor
I'm the
and
executor.
there's a trust, but you don't have a copy of the trust? I'm gonna let you take that one.
Yeah, you could probably both. You might be the executor through the will and the successive trustee. So your parents are in charge as long as able. But when they pass, you'll be appointed as a trustee. There's paperwork that we draft to do that.
Could she go
Yeah.
to the attorney who drew up the documents and
That's
get
why
the
we keep
document
copies,
that
but
way?
there's a uniform trust code in Ohio,
Yeah.
so you can request a document from that attorney and they have to provide you a copy.
Okay.
Then all 10 beneficiaries, grandkids included, can request a copy as well, and you have to provide that.
Now,
Then there's some
another
accounts to
question
be
I want to ask. The main assets that they have is property. It's all in property.
It's a big use of the trust nowadays, kind of simplifies probate and all that, yeah.
So, I know their request is to sell everything and then split it a certain percentage. But both of my parents are older, quite older. What does transfer on death deed do? Because they still owe on the home, but they own all the land, if that makes any sense.
So let me repeat. What does transfer on death do is basically what your question is.
Yes, does that override the trust?
Does that override the trust?
Yeah, if it's not titled into the name of the trust, like we talked about, the trust does not control that property, that
Okay,
asset. So if
so-
it's in their name as an individual and they have TOD to one child,
Okay.
not all 10 places the trust says to send it, that TOD trumps the trust, trumps the will, and gets it to that one child.
It's like the beneficiaries of an IRA. The beneficiaries
have
are
TOD on your
set in
property.
stone.
Now, when I see they have a trust and went to that time and expense to do it, and it allows for more sophisticated distribution, especially with properties, that's why folks have it, it's not a name and a percentage, I would say they should be using the trust, if they have it.
Now, with both of them being still living, is there a way to do a transfer on death deed?
They can execute it
With both of them to me,
if they choose.
if they choose, but.
And they're
it'll be
competent.
better to get a lawyer to.
Well, they're gonna draft it for you and record it for you, but,
So wait, I want to make sure that I understand this question, because I think what you're asking is, can they do a,
I'm sorry.
it's okay. You're asking, can they do a transfer
On death deed.
on death deed to you? If their ultimate goal is for you to own the property, then that would be fine. But if their ultimate goal is to divvy it up among a bunch of other people, then it could be, depending on the value of the property, it
About
could,
it is, the other people can't pay.
well,
I'm the only one that can keep the property going and pay on the home.
then that's the use
So
of the
it gets
trust
paid
for you,
off.
that's the use of the trust for you.
And then I would honor what mom and dad still wants to do.
That's the use of the trust,
That's
that's,
not my goal to take it over.
okay, we gotta know mom and
I just
dad's
wanna
goal,
know.
but that's use of the trust, allow you to be more specific with distribution. It's not just, like Monica said, a
Okay.
name and a percentage, a winner take all.
and you want to make sure too that it doesn't, that you don't do something that's going to impact you negatively from a tax perspective. And that was one of my concerns, thinking about this situation, but that's,
I never thought about that.
yes.
Capital
But
gains,
it's-
so that's very.
It's either weighs pros and
Right.
You're either gonna keep it or you're gonna lose it.
Yeah, and then using the trust, if you want to buy out the other beneficiaries, you can, and blah, blah, blah,
Yeah.
right of first refusal, la, 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 so it's the
Okay.
trust. There's no question.
All right, thank you. You mentioned,
Oh, you're fine.
a power of attorney.
Mhm.
Say my brother's the power of attorney. You say my mother passes, you said that the power of attorney ends. How do I keep that going so that?
Can't. That document expires when mom passes. It's a lifetime responsibility. Then we say, okay, we have to look at how are all these assets titled? Is something in the trust? Then we look at who's the next trustee. Something not in the trust, is there a beneficiary? Something not in the trust, but there's no beneficiary, let's use the will. I mean, so that's how we kind of watch, that's why I say we watch how things are titled so closely.
So what
The power of
happens-
attorney expires when mom passes.
So what happens after, like, let's say you do have a loved one who passes away, and you were doing all their power of attorney, let's say you were doing their financial power of attorney before that, then what do you do after they pass away?
Well, then we have to title them, Chris. So we look at all the assets, laundry list them, and see how they're titled. So if it has a beneficiary, we say, let's start calling the banks, the insurance companies, whatever, and get those claim forms. If it's in the trust, we start doing the paperwork to give the succession to your brother as a trustee. If it's nothing titled, then we say, hey, we gotta get the will, let's look at the wishes of the will and start going through that court process. That's why we fill up the buckets, we say. We hope the probate bucket's minimal and everything else is, yeah, so.
That's a great question. I think you had a question?
So, we're planning all of this to make sure all of our wishes are taken care of. In the situation of a cemetery and your wishes, you buy a grave, put a monument up, then you die. How is it a child can come in and say, but mom didn't really want to be buried, I want to return the grave, you can get the money.
Oh, so,
That has happened several times.
okay. So you pre-purchase your burial stuff, and a child or heir comes in and says, we want to undo that and take the funds. Whew, I've
Yeah.
not run into that, so I'm
And
gonna
not
leave that one to
often.
you.
Most folks many folks at our clients' life stage are doing the prepaid burial arrangements, goods and services included, not just monument and such, because it ease, kind of, gives the kid some direction, your wishes. So the only thing you can do to contradict that is put it in writing. So we'd add that language to your trust or will, that those are your wishes. Because if you put it in writing, then we can, what that child wants to do, the other beneficiaries can take them to court and say, well, that's not what mom wanted, here's why. May not be, the best thing. They may say, we're not going to court, but yeah.
I always thought it was so nice that, when people kind of planned ahead and, expressed their wishes. My mother-in-law passed away, and her family, it was sudden. We didn't know it was going to happen. And her family, they were all devastated. I mean, and so then they're making all these decisions, and I was like, what kind of a burial do you think she wanted? Oh, we don't know. What kind of, so it was kind of like all of these decisions had to be made at a time when nobody was capable of making those decisions. And so my thinking is like, get all that stuff written out ahead of time. There's that book that you have back
The more
there
in writing, the
basically
better,
does
but may
that.
not be bulletproof.
But
Yeah.
then the child would need to say, yes, there is a will and this was the wish. But I worked
Yeah.
for a cemetery and it happened more times than I
Wow.
could read.
Oh.
I said, why would the parent buy a grave and a monument and then tell you they want to be cremated?
Yeah,
And that just broke my heart.
yeah.
Yeah.
Well, like you said, put it in the
Put
will,
it in
right?
writing,
Make sure
yeah.
it's in the will, so that if that happens, somebody
The more in
else can
writing, the better.
contest
We do
it.
that with the grandfather clocks if they think they're gonna bicker over that even.
Yeah, yeah.
Anything in writing works, even with personal property.
There is this website that you can go to where you can secure it's a digital archive, so if you have art or heirlooms or like the grandfather clock that you're talking about, you can label them ahead of time, you can categorize them, you can name the person that you want that to go to. It can be kept private. You can tell the story. You can even do like a voice recording. And by the way, that is misspelled on purpose because that's how they spell the company. So that's not a misspelling. That's actually the website at the bottom there. But you can create audio, video files, and basically have a unique QR code that's associated with each item. So for somebody who's a collector, this can be a great way to make sure that the things that you want to go to certain people do go to those people. And it's also good for insurance purposes because you have an inventory of all your stuff.
Yeah.
I got one more question.
Yes. Oh, sorry if you were still
Say,
copying.
for instance, if something happened to your parents and their home needed some remodeling, and the trust is made out a certain way. Now, if I had to go in and put money into that to fix it up, can I take that off of the top of the money once everything was sold, or how would that work?
Yeah, I mean, that's kind of the prudent investor rule. So the trustee has a responsibility to maintain the assets in the trust the best they can. If you're going to sell it, you probably just sell it. Don't spend too much money fixing it up. Because the other beneficiaries can complain of your use of the monies. So you just have to be reasonable and make sure it makes sense to
Just save
everybody.
all receipts and.
Make sure it makes
everything
sense.
else. Okay.
It's a good financial plan.
Thank you so much for letting us come
Yeah,
tonight.
thank
We
you very much.
appreciate it.
Well, I've listened to Chris and Monica many times and my head spins every time. So I'm sure all of you have a lot of information to process. Please reach out to us with any other questions. You can visit our website. It's cincycare.com. You can also email me, and I can connect you with whoever's on our team. If you have any questions about care, we have Matt Maloney, who's on our team back here, Christine Lavin, Monica, Chris. We have a volunteer, Barb Markey, back here, and Barb also wrote this book. She is the author. It is called Did I Forget to Mention? All in One Place, Just in Case. It is a book that walks through everything you could possibly need for information. So it goes step by step. It's $15. If you'd like to talk more about it, you can talk with Barb. We also have these cards. They're blank inside. We have an artist. Her name is Suzanne Bryan. She works with seniors with cognitive impairments. All of the covers on the cards were created by a senior with a cognitive impairment, mainly Alzheimer's or dementia. It's $10 for a pack of 4, and the proceeds go back to care if you're interested. I know a lot of us don't sit and write cards anymore, but I love to write cards, and they're really special. There's all different ones back there. So thank you so much for being here. Thank you to Steve and to Hope Church. We're so excited to be here. 5 more weeks. We have many more topics to come. So please join us as the weeks move on. And if you need anything, please call. We're here for you. Okay? All right. Have a good night. Be safe out there. Take care.